My name is Ryan Bauerle, and I'm a partner at Goranson Bain Ausley, and I'm board certified in family law. Today I'm going to answer the question of what happens to a closely held business during a divorce. On some level, a closely held business is treated like any other asset. First, it needs to be identified, characterized, valued, and then it can be divided. The court can divide the business in several different ways. So specifically, as to what will happen to a closely held business in a divorce, there are a few options. One, and what happens the most frequently, is one spouse will buy out the other party's share. This will often allow the parties to maintain the status quo when you've got one partner who's just more heavily involved in the day-to-day operations of the business. He or she can continue that role. The other person receives some sort of compensation for the community share. Another option is the business can be sold. This happens where the parties are just generally unable to agree on what will happen with the business post-divorce, or sometimes there's just not enough resources available to purchase one spouse's shares from the other. Finally, and this is something that we generally don't recommend, is the spouses can continue to operate the business post-divorce, but as you might expect, there are some problematic concerns about operating your business with your spouse after you're divorced. While there are significant risks in operating a business with your ex-spouse post-divorce, if the parties can collaborate, it still might be a viable option. My top piece of advice for somebody who is going through a divorce where a closely held business is at play is to begin gathering information early. And this also includes putting the right team together with the right lawyers and the right experts.